President, Islamabad High Court Bar Association, the General Secretary, the other office bearers, learned advocates, Assalamu alaikum. I feel honored to be here and addressing this wonderful, respectable gathering of lawyers and others. Imparting education on law are not offering ethics for lawyers as a subject. It is only when a person is qualified as a lawyer and he is enrolled as a lawyer in the Bar Council, the rules about ethics and discipline become applicable to him, but even then, he is not aware or familiar with those rules. As Aamer Saab, the Honourable Secretary, he pointed out that our system, legal profession, the way it used to be, is no more the same. In the sense that a newcomer, a freshly graduate lawyer, apprentice, used to join some chamber to learn not only how to practice law in the sense of legal education and development of the acumen, but also the mannerism, the way he should conduct himself, the way he should deal with his clients, the way he should deal with the court. We have lost that. It's unfortunate. Why? Would not like to go into that. The way system has evolved, the way things have happened in the last couple of decades, that has seen decline, that has seen erosion of that system. But the fact remains that now the concept of chambers or firms teaching their pupils, freshly graduate lawyers, is no longer there. And what we experience and see in courts today is primarily the result of that same. The reason I am standing here and addressing this gathering of all qualified, learned advocates about a concept like ethics is only because of that. Because this was something we used to learn at home, and by home I mean our chambers, our firms. And we have to keep the one thing in mind, that lawyers of today is the bench of tomorrow. The judges of the superior courts, of the subordinate courts, are appointed from among you. Not very long ago, I was a practicing lawyer. All four of us, the judges at Islamabad High Court, or for that matter any other High Court, or even the Honourable judges of the Supreme Court, all of them almost, except the ones who have come from service, they were practicing lawyers. They were from you. And upon retirement, we have to return to you. Because primarily we are advocates. We are here, as one of the Honourable judges of the Supreme Court used to say, we are here only for a short time on deputation. And we will be involves two relationships. One, which a lawyer or an advocate has with his client, and secondly, which it has to the court. Because an advocate is a bridge between the litigant and the court. Whatever the litigant, the claimant, the defendant seeks from the court, he or she seeks through a lawyer. So, arising from these two relationships which an advocate has, he owes two duties. One to his client and the other to the court. Let's first see what the duty is, or what does it entail when we say that an advocate has a duty towards the client and to the court. Of course, the advocate represents his client and charges a fee for that. He's in there for money. This is the profession, bread and butter. But he also has certain standards, certain principles to observe. And those standards, those principles encompass his duty towards the court. The first and foremost is that any advocate should represent his client independently, without any influence or favor, seeking justice for his client. And when we say seeking justice, as one of the great judges of England, Lord Denning, observed, there is no such thing as justice. There is always justice according to law. So, when an advocate presents his case before the court, he is to ensure that the claim that he is making in the court falls within the parameters of the law. Right? And he is to assist the court accordingly. An advocate must never mislead the court about any fact or law. That is his paramount obligation. That is his principal duty. Never ever make a submission or a statement which amounts to misleading. We experience, we encounter that general statements are made, or even a statement about law is made, which never are true, which never are correct. I would not like to name the lawyer, he's a very senior lawyer, but once he said, this is the general conversation, that while you are having a discussion or in a meeting, just tell the meeting that there is a case law on that subject which is reported as PLD so and so. So I asked, what if that is not correct? And he said, who cares? He'll find out later. For the time being, you have made your impression. That's not true. That's not how it should be. An advocate or a lawyer is never ever supposed to do that. He should never mislead either his client or even the court about facts, about the law. And when the court is concerned, since we are dealing with the duty towards the court, no such statement is made which the advocate believes or has reasons to believe is not correct, or the law which he is not sure of that is the correct position of law. Secondly, an advocate must not exploit or abuse his position as an advocate. He must not. It is his obligation and duty to assist the court and not to abuse the position as an advocate by exerting influence or by doing something which amounts to abusing the position. Now, having said that these are the two primary obligations which an advocate has, internationally what is recognized as would constitute a breach of duty is one where an advocate does not ensure or takes reasonable steps to ensure that he or she should not waste the court's time. Remember one thing, that a judge, wherever or whoever he is or she is, when sits in the court, it's a public time. It's not a private time for any judge. He conducts the proceedings for a prescribed time. An advocate has to ensure that his arguments, his presentation should not be such that it amounts to wastage of court's time, because it's public time and he or she would be doing it at the expense of the other litigants. In West, there is a system, of course, where the advocates are asked in advance to tell the court that how much time they would be consuming, and an allocation is accordingly made. So if an advocate or a lawyer in the pre-hearing proceedings say that I would be taking 15 minutes, 20 minutes, half an hour, then that slot is allotted to him. And he or she has to address arguments within that slot. And if he exceeds or does not adhere to it, then of course he is penalized. So as an advocate here as well, because I think the courts in Pakistan are overburdened, the advocates more so should be very careful in the time that they consume while presenting the case. Secondly, the advocate must ensure that he in advance has apprised the court of the legislation and the law that is involved or entailed. In a way, pre-disclosing the laws that are involved, so that the judge is familiar, so that the judge knows, right? Because at times in 10, 15, 20 minutes, it is not possible even for the judge to comprehend the entire material. And if the law, legislation and case law is told in advance, the judge will have the benefit of going through the same. And in the luxury of his chambers, could apply his mind. Well, one can argue that this would amount to like prejudging the case, but a good judge must bear in mind that when he reads through the file, it's only a tentative assessment, and the final making up of mind or deciding the case only where the arguments are addressed. And that is the very concept of our adversarial system. Thirdly, which is very important elsewhere as well as in Pakistan, is management of case diary, clash of dates, and communication of the same to the court. I can share because I have graduated from there, so I've seen the system. In England, if a barrister has more than 2 or 3 dates on a particular day, he is penalized. And it is expected of him that he would manage his diary accordingly. So here as well, we see every day that a request is made that Mr. So-and-so is before the Supreme Court, before some other High Court, some other place. That's fair enough. These are the exigencies of the system. We all are practicing lawyers and naturally has more than one case, but try to minimize it as much as possible. Make sure that there are no clash of dates. Request the court, plan your things accordingly, so that when the case is ripe for arguments or is fixed for arguments, there is no clash, there is no adjournment sought. I can't really comment about the other courts, but can speak for sure about this particular High Court. All 4 benches sitting at the moment conducting cases. We sit there with a frame of mind that whatever is the cause list, we exhaust it and decide the case, not to just prolong it or adjourn it. Right? So I can urge you, I request you that likewise, please plan your professional engagements, diaries in such a way that there is no clash as such. One can say that yes, of course, that's not practically possible because case is fixed before the Supreme Court, case is fixed in the lower court, trial is being conducted, model courts are conducting trial. We can work out the arrangement between us and with the representatives of the bar that the system that they have in the Honourable Supreme Court for proposed list and then finalization of the list, where the lawyers have the privilege of addition or deletion of cases or adjustment of cases, we can have a similar thing. Why not? Yeah? or the list can be issued for the entire month or for the 2 weeks, so that lawyers can well plan that they have to be here, they don't have to be here, and they can plan things accordingly. But till that is done, until measures are taken, please manage, plan your things so that there is no clash of dates. And wherever there is, I mean, at times it is inevitable, it's unavoidable, fair enough, one understands, please have the courtesy of informing the court in advance, and even your opposing lawyer. It is seen like almost every day that a request for adjournment is made on the spur of moment. The opponent complains, the opposing counsel complains, I have been preparing the case, I spent such and such hours. What about that? Now, his complaints are justifiable. He's justified in that. Even the court should be informed in advance so that the court also sets aside the case. Like it happens in Supreme Court. I mean, some of the courts used to observe wherever there was a request for adjournment, they used to adjourn it like right in the beginning. So try to manage things like that so that minimum or no discomfort or inconvenience is caused to the court or even the opposing counsel. Okay? Again, I repeat, I mean, I can speak for this court, Islamabad High Court, that no judge here minds adjournment if in a proper way that is asked for, requested, right? So anyone or all of you would be accommodated accordingly. Why not? We have come from the system, we know how it operates, right? But only so that your opposing counsel is not put to any inconvenience, the court is not put to any inconvenience, please just inform in advance. Now, a few words about duty to the client. That's again a very important relationship because your client is your paymaster as well. He is paying you for the services he has hired you, right? Regardless of that, in that relationship, you have to be very candid, serious, and straightforward. So many times it happens that client would tell you the set of facts, and on the basis thereof he would ask you to present his case, and you know that no case is made out. Please inform him accordingly. Do not mislead your client. Do not impart false hopes. Right? Just tell him the state of facts as they are. Right? You might be losing money if he says, no, I will not engage you. But that would be no burden on your conscience at least. Right? So it is important for any advocate to be just straightforward to his client. Just not mislead him. Just be very straightforwardly, candidly tell him that this is the state of affairs. And if he still wants to continue, then it's his choice. Right? Legal representation is his right. But at least you as an advocate have done your duty, have told him the relevant things. Secondly, as an advocate in these times of change, need to be abreast. We need to keep ourselves updated with the law. So please have all the search engines available to you. Keep informed what the state of law is on a particular subject which you practice. That is very important. Thirdly, have no interest adverse to your client. We see that at times there is a clash of interest. Please do not do that. Please avoid that. there are also experiences where the lawyers, the advocates, say are making a claim on behalf of their clients for a property. They make an arrangement with their client that we'll get you the property, half of it is ours. Right? In Pakistan, we do not have a concept of contingent fee. I'm not sure, I don't think there is any bar on it, but as such, that is not in practice. In states it is. In UK, the system which we have inherited from, that practice or that system is not involved. So contingent fee, having a share in the property, having a share in the claim is inappropriate as far as our ethics, our standards are involved. So please do not do that. Avoid that. That is not appropriate. That is, or that would constitute as a misconduct here. That would amount to violation of your duty which you owe towards your client. Now, lastly, the duty towards client is of a general nature but is of grave and utmost importance, that an advocate must not behave in such a way to diminish the trust and confidence which the public has in your profession. We as part of the legal fraternity, we as advocates are to conduct ourselves in such a way that people should have confidence in us, should have confidence in the system. Unfortunately, we read in papers time and again that there are incidents which happen which really brings the profession in disrepute. Please do not do that. Please avoid it. Yes, our system is flawed. Yes, our police system doesn't work properly. Yes, the court system is not ideal. But we as lawyers, we as advocates, we as part of the legal profession must keep that in mind. There was a time, and that is still the time, that advocates, the lawyers, were regarded as intelligentsia of the society, and as the higher category, as the intelligent people, should not conduct ourselves accordingly. So we should not, towards our client, behave in such a way which brings the profession in disrepute, or the public loses confidence in the system. So one has to ensure that. Now the question that arises is, what if circumstances arise or anything happens that there is a conflict between a duty owed to the client and duty owed to the court? What if one has to choose between the two duties? Well, then generally it is regarded as that the duty owed to the court takes precedence over duty owed to the client. So wherever there is such a situation that there is a conflict and one has to choose between the two, the duty towards the court takes precedence. Right? So keep that in mind and make sure. The other general thing, before coming to the specifics, is something which is important internationally, here as well in Pakistan. The advocates and the media. Though I am aware that on, I think last week it was, the Honourable Chief Justice delivered a speech about social media and judiciary and social media and law, but here it's something different I am addressing. Advocates making statements either in press or on media about pending cases. In the cases in which they represent their clients, or they are there making a statement or saying something just by whatever they are observing. They are not involved personally as such. There is no bar even for an advocate who is conducting a case, not to make any statement, either on media or in press about his case. But he has to be very careful that he should not make any statement or say anything which prejudices the case or the trial, which amounts to speculation, which amounts to anything which will tomorrow be maybe contempt of court. So, by all means appear on media, by all means make statements or say whatever you want to state, but say whatever is the fact and the position. Don't be speculative. Don't be a judge. Don't do anything or say anything which can amount to contempt of court or can even prejudice the case. Now, we see experiences every day that mostly lawyers do appear on media and say about cases in which they are not part of that case. And we see that, most of the times, or at least at times, they are judgmental. They give opinion in such a positive way, in a dogmatic way, that yes, this will happen. Yes, this will be the result. Yes, this document would be rejected. Yes, this document would be accepted. No, please do not do that. Because it is only the court that can determine what the result or the fate of the case is. By making statements in the press or on media, don't conduct a parallel trial. Say whatever you know is the correct position, and that's about it. Because whatever is said or told on media, that has impact, that has implication. Because masses, the people, they are not watching the court proceedings. They are only getting to hear and see about a case from either the press or the television. Right? So any word you say would prejudice the trial, because tomorrow a member of the public would say, well, this eminent lawyer said this and this thing, and the court has decided otherwise. How could they? This was not the law. No. Media, of course, is to convey and show the people whatever the correct state of affairs is. So likewise, an advocate, it's your duty to say on media whatever is the correct state of affairs is. Don't be judgmental. Don't be too strong in your opinion about it. Right? Now, just before going to the specifics, one final thing, that all these things which I have just said, though I have looked around and found out that yes, this is the concept of ethics and discipline in West, in UK in particular, in states as well, but this is also the case in Pakistan. We also have hard rules and regulations. All of these things, not worded in a similar fashion, but their concepts are there. Pakistan Bar Council has framed rules which are titled as Canons of Professional Conduct and Etiquette. So I would request all of you to please go through these rules. It's like about, I think, 2 or 3 pages, nothing as such long. And whatever I just said, that they are there. I think they are a bit outdated and need to be updated, but they have this old concepts, but they are there. So please do read these rules for yourself to be acquainted with that what is expected of you as an advocate by your regulatory authority, by the Bar Council. Okay? And I also would take this opportunity to request the Bar Councils, Pakistan Bar Council and Islamabad Bar Council in particular, to please update these rules on conduct and bring it in line with the challenges of today, right? Because legislation or rules or regulations which we frame are not meant to be stagnant. They need to be updated every day or with the changing times. So every year, maybe after every 2-3 years. Now, the more interesting bit, and that is the everyday observations and experiences which we as judges here, at least in Islamabad. Though personally speaking, I do also exchange notes with my colleagues in Sindh and Punjab, that what do they experience. And from what they tell, I mean, I can assure, and I was sharing it with Raja Saab, the president as well, that things in Islamabad are much, much better than Punjab. So, yes, of course, we are far ahead of other provinces. But again, there is always a room for improvement, and we need to improve ourselves. We have to move forward. We have to ensure that we are the best in every way. First thing, which is like almost now an everyday affair, which at least I notice, and I think my Lord Mr. Justice Mohsin Tarkiani also has now started doing it, is the dressing. In this category, female lawyers outclass the male anytime, right? Because there's no complaint. But with the male lawyers, one general complaint, mostly, not everyone of course, but some of them, tie. Please, when you wear your tie, knot should be proper and it should not be down, hanging. It's a tie, not a hanging thing. Hanging noose नहीं है कि आपको लटकाने नहीं लगे, इसमें कोई फांसी नहीं चढ़ने लगे. It's just a tie. Tie the knot so, I mean, you don't have to like strangle yourself or choke yourself. Lightly, easily बेशक बांधें, लेकिन इस तरह बांधें कि it should not be down. It looks very awkward, it looks very casual. So, all the young lawyers in particular, please, in the morning when you leave home, leave offices, make sure that your tie knot is proper. And also one thing, which whenever I ask them, correct them, point it out, they start correcting themselves there and then on the rostrum. Please, the courtroom is not a changing room, it's not a dressing room that you have to do wherever, but not in the courtroom. Okay? I mean, I understand their point as well. I mean, it's an immediate reaction that they have, that they need to correct themselves, but leave it. ठीक है, what has been done has been done. ठीक है, so अपने आप को जो ठीक करना है वो या तो घर से या दफ्तर से या बाहर रूम में देख के आए कि मैं ठीक लग रहा हूँ कि नहीं लग रहा. Don't do it on the rostrum. So please. Secondly, linked with that, winters are around the corner and the uniform will change soon. We will have gowns for lawyers. So please, when you appear, please wear your robes. Gown पहन के आया करें. Again, this is something which youngsters should keep in mind. और gown properly पहने. और अगर कहा जाए कोर्ट में कि ये आपने gown नहीं पहना हुआ, properly dressed नहीं है, तो कोर्ट में किसी से borrow करके वहीं ना पहनना शुरू कर दिया करें. Again, this is not a dressing room. ठीक है, it's a courtroom. Okay, so please keep that in mind. Secondly, when you are on the rostrum, you approach the rostrum, there is certain mannerism in which you stand. Very few, I mean, experiences there, but yes, of course, there were experiences in some cases. A lawyer was there, while arguing, was chewing a gum, had a gum in her mouth. I'll disclose that. It's a gender thing. It's inappropriate. It's very inappropriate. It's equally inappropriate if a judge is sitting on a presiding chair and has something in his mouth, a sweet or a gum, wo bhi ek gair munasib cheez hai. But even for an advocate who is on the rostrum, who is to argue the case, who is to address the court, please do not have anything in your mouth. That gives a very casual, again, a bad attitude. I don't know, one or two experiences are there, but they were because of what, nervousness or whatever, but lawyer was biting nails while, I mean, on the rostrum, and other side was arguing and was continuously biting nails. I think it's nervousness, and I mean, I have to tell everyone that, the court is not something, so drowny jagah ya drowny cheez to nahi hai, judge. So be relaxed, normal, right? Be at ease, and you'll be at your best when you'll be relaxed, right? So there's no need to be nervous. I mean, biting nails, yes, of course, some of us have this habit, but please don't. At least on the rostrum, don't do it. One of our lawyers from Lahore, and now is a sitting judge of the Lahore High Court, he had this habit. He used to bite his nails consistently. We used to tell him, please don't do it. I don't know what he does now when he's on the bench. But, he had this habit. Thirdly, please ensure, and this is now I am saying to the seniors, the senior members of the bar, when you are not available and you are asking your colleague, the younger colleague, to seek an adjournment, please do not send anyone who does not have license of the High Court. Again, it is noticed time and again, not only in this court, but generally all the courts, that young lawyers appear and yet they do not have the license. ऐसा ना करें, ये उनके ऊपर जुल्म है, ज़्यादती है, वो बच्चे हैं, यंगस्टर्स हैं, कोर्ट अगर कोई इनको ऐसी चीज़ कह देती है, they get nervous and rest assured जो पहला impression आपका होता है, अगर वो गलत हो जाए, तो then you are scared and you take things in the negative way the rest of your life. Right? So youngsters need to be encouraged, but encouraged in such a way that they are not really, exposed to things which are disastrous. So while sending your younger colleagues for adjournment, please ensure that they are license holders of the High Court. Right? So I urge this to the senior members कि अपने जो young colleagues हैं उनको ना इस चीज़ से expose करें. Linked with that is, again, something which we lack now and which we don't do. And the experience tells when you ask something, they don't know. So when younger colleagues are sent for adjournment, ask them to please at least acquaint themselves with the file. ये as a senior, जो senior members हैं, उनकी फ़र्ज़ है, एक duty है, कि they should tell their juniors, they should tell their younger associates कि please file तो देखा करें. At times, the people appear and you ask them, whom do you represent? They don't even know कि वो petitioner की तरफ से, कि respondent की तरफ से adjournment मांग रहे हैं. So ensure that to encourage the concept of reading, ask them to please go through the file, read the file. Okay, they're not good enough to argue, fair enough. Understand the limitations of a client and everything, but at least they should be familiar with the file. So whoever appears for adjournment, seek adjournment, your adjournment will be granted, but at least the basic facts of the file, whether he's for petitioner or respondent, he should know that. Then another common thing, which again I don't know the reason, but we see and experience every day. And in my court, Raja Khalid Saab, the Deputy Attorney General, is a witness to it everyday basis. When on the rostrum, one should only address the court. There should be no crosstalk. I say things in a lighter sense, in a lighter way, just to, put the message across and also not to offend anyone. That I say that this is a court and not a talk show. Don't crosstalk. So please, when you are on the rostrum, your only focus is the presiding officer, the court. आपस में जो अगर कोई एडजर्नमेंट की बात करनी है, अगर ये पूछना है कि आपने जवाब दिया है कि नहीं दिया, या कोई और ऐसी चीज़ आपस में डिस्कस करनी है, bar room is there, outside the courtroom you can do it, but when on the rostrum, only address the court and the presiding officer. That's about it, no one else. One other general thing, and especially in the case of youngsters, and I would urge the youngsters, they are, most of them now, when they start profession, right from the word go or from day one, they are solo, they are independent. Nothing wrong with that, it's good. But it's a request to them, learn the ways of profession. And by that I mean, when you are on the rostrum, when you are arguing a case, again it is a common observation that you ask a simple thing, a simple fact about your case. They do not know that. Now, the reason I do not know. One reason, of course, which I know, is probably they have not drafted the case themselves, so they do not know the basic facts. Because if one takes the brief directly from his client and drafts the case himself, I can rest assured that you know the basic facts. I mean, as experience, my experience as a lawyer, the case which I drafted and I had the briefing direct from lawyer, I didn't even need to prepare that because आपको पता होता है. So please try your best to take the briefing from your client directly and draft it yourself, or at least if you have not done it, then go through the file in such a way that you know the basic facts, that when the court asks you the basic questions, you should know that. I mean, at times, such basic questions that you ask them, on which page is the impugned order or the notification or whatever you have challenged, they don't know. They start shuffling the file. Right? And I mean, I don't know, some of you are young sitting here, some of you are experienced. The ones who are experienced, they must have appeared before my Lord Mr. Justice Jawad S. Khwaja, as he then was. And if you shuffle the file in front of Mr. Justice Jawad Khwaja, you have it. Right? No. The basic facts at least should be on your tips. Okay? So, youngsters, please, when you appear before the court for arguments, be familiar with the law and the facts, and facts in particular. Law, no one is a master. At times, a judge asks the questions which you do not know. Fair enough. Nobody knows. And if the judge asks any such thing which you are not aware of about the law or the fact, take time. Ask for an adjournment. Nobody is refusing an adjournment. Instead of feeling embarrassed before the court, shuffling the papers, not knowing or being adamant that I know, would not serve you any purpose. Right? All four of us who are sitting here, we are willingly granting adjournments on that because, you see, law is such a thing, such a vast subject. Nobody is expected to know everything. Even we as judges, though we are supposed to wear the laws on the sleeves of our robes, but that's just a saying. We do not know everything. Nobody knows it. So we also, like in certain cases, in the propositions where lawyers do not assist, we also research on our own. So as lawyers, you should be more willing to do that. So whenever you are confronted with a question, particularly a legal question, and you are not sure about the answer to it, please, don't feel shy, don't feel embarrassed. Seek an adjournment, research, and come up with the answer. The law almost is settled on almost everything. Right? The answers are all there in the books. It's only that just we don't look at it. So please, youngsters, when you come prepared. That's almost like everything, but in certain cases, but that's like very rare. They don't even know how to address the court. They don't even know how to call a judge or how to take his name. In most of the cases, when you ask where your counsel is, where the principal counsel is, and they would say, Ji, Aamer Sahab ki court mein hai. No, don't do that. Under the law, a judge of the superior court is supposed to be addressed as Mr. Justice so-and-so. So please tell your associates and those who are associates and sitting here and are young counsels, please address, whenever you address a judge of the superior court, Supreme Court, any high court, you address a judge as Mr. Justice so-and-so. Right? And that is how, because the law requires, there's an order to that effect that a judge of a superior court would be addressed accordingly. Now, these were the just common observations. One final thing before I take leave. Why? Why is it important that ethics or the conduct should be observed? It's because we as advocates, we as lawyers, we can't advertise ourselves. Profession mein, advocacy mein, as a lawyer mein, there's no concept of advertisement. And your only advertisement is, or are rather two, I would say, your colleagues or your client. And your advertisement is, or by word of mouth. If a client is happy and satisfied with you, he would tell his colleagues, his friends, his relatives that Mr. So-and-so is very good. Your colleagues would say that Mr. So-and-so is really well versed in the subject. He's a man, upright man. He's a man of integrity. Courts respect him. Right? Because at the end of the day, as I said in the beginning, we all are colleagues. If I'm on this side of the room, that means nothing. I'm here for whatever period I have under the law. At the end of the day, I have to return back to you as an audience sitting there. In years to come, someone from you would be standing here and telling about ethics or some other subject. As I said, lawyers of today are judges of tomorrow. Right? So, knowledge of law, of course, that is required, but reputation in your conduct, the way you carry yourself, is very important. So please adhere to the conduct, adhere to the rules, regulations, ethics bar, so that you also excel in that. Right? In the end, I would thank you for granting me this hearing, patient hearing. I hope that was of some benefit to you. Right? See you in court. Thank you.
माशाल्लाह माशाल्लाह। अब दोस्तों से गुजारिश है कि बैठ जाए।